In this lecture podcast, I take up topic 8, which is about law, fact, and evidence. And in particular, we examine how courts in undertaking judicial review actually consider evidence that has been used by original decision makers or not used by original decision makers in arriving at their decision. And yet, that becomes a subject for judicial review. We must remember that questions of fact and questions concerning evidence are typically the sole purview of a merits review process. That is one, for example, undertaken by the Administrative Appeals Tribunal, whereas judicial review is limited solely to questions involving errors of law or questions that involve instances when a law might be violated in the course of decision making. So judicial review, therefore, typically does not concern itself with matters of evidence nor facts. But as we shall see in this lecture podcast, there is in fact an instance when judicial review would actually take up issues of fact and issues of evidence. And that is what we will cover in this specific lecture podcast. So after studying this topic, you should be able to discuss and explain no evidence as a ground for judicial review at common law, no evidence as a ground for judicial review under the Administrative Decisions Judicial Review Act of 1977, and the rules of evidence and fact-finding by administrative tribunals. So let's begin by just reviewing a bit what the basic principles are that concern judicial review. So as far as judicial review is concerned, the factual correctness or factual errors on matters of, or those which involve matters of evidence or fact, these are matters or considerations that fall outside the scope of judicial review. And so therefore, issues pertaining to factual correctness or factual errors or those that involve matters of evidence or fact properly belong to merits review and not judicial review. And so therefore, as a basic principle and as an important rule, judicial review, given its limited scope, does not look into the merits or factual correctness of administrative decisions. So the reason for this is that courts, the duty of courts is mainly to examine errors of law. And so therefore, when it comes to questions involving evidence and factual correctness of decisions, that has to belong to the executive. And for that reason, part of it is out of a respect of the courts not to encroach upon the powers of the executive, which is a co-equal branch of government. And so you can therefore appreciate that prior to the enactment of the administrative decisions prior to the enactment, for example, of the Administrative Appeals Tribunal Act of 1975 Commonwealth, it was difficult, therefore, for applicants who were aggrieved by administrative decisions to be able to seek redress of such a decision, mainly because their only recourse would be to go to courts for a judicial review of the administrative decision, and yet such a legal remedy would be limited to an examination by the courts of the legality of the administrative decision. And certainly it wasn't within the power of the courts undertaking judicial review to examine the factual correctness of administrative decisions. So therefore it was a welcome subject when the Administrative Appeals Tribunal Act of 1975 was passed by the Commonwealth Parliament, which then opened the doors for applicants aggrieved by decisions of administrative decision makers to have such decisions examined on the basis of factual errors or on the basis of merits, which can involve questions of the correctness of the decision or preferableness of the decision. And yet, given the fact that the AAT Act of 1975 was enacted by the Commonwealth Parliament, questions arose as to whether or not matters that would involve an appreciation of evidence belonged exclusively to administrative tribunals, or there were instances when, in fact, evidence can become the basis, or issues on evidence can become the basis for judicial review. And as we shall see, based on common law rules, as well as on the basis of the enactment of the Administrative Decisions Judicial Review Act of 1977, there are, in fact, instances when courts can undertake judicial review of administrative decisions on the basis of evidence, and in particular on the basis of a lack or absence of evidence when the decision maker arrives at an administrative decision. So, as a basic principle, for example, in common law, it should be clear, therefore, that as a basic principle, courts will not examine errors of fact. So in Waterford versus the Commonwealth, for example, Justice Brennan said that there is no error of law simply in making a wrong finding of fact. So even when an administrative decision maker makes a finding, and that finding involves an error of fact, that will not justify a judicial review on the ground that that would involve an error of law. So the mere fact that a decision is founded on the basis of a finding of fact that is erroneous or wrong will not lend itself to a process of judicial review. Because in that case, even when there is a wrong finding of fact, that does not constitute an error of law as to ground it as a basis for judicial review by the courts. As well, under common law principles, even if there is a defect in the reasoning used by a decision maker in arriving at its decision, even if that reasoning were demonstrably unsound, that again will not support a conclusion that there is an error of law, again, as to justify an intervention by the courts through judicial review. So, for example, in Registrar versus the District Court ex parte White, Justice Menzies said that even if the reasoning whereby the court reached its conclusion of fact were demonstrably unsound, this would not amount to an error of law on the face of the record. And to establish some faulty, example, illogical inference of fact would not disclose an error of law. So we can see, therefore, that the bar, in a sense, for judicial review of administrative decisions on the basis of a problem with evidence is quite high. Because on the one hand, as we said, even when a decision is based on a wrong finding of fact, or even when a decision is based on a reasoning that is demonstrably unsound, that will not justify an intervention by the courts through the process of judicial review. As well, even at common law, even a want of logic. So in other words, if a decision seems to be illogical, that alone is not synonymous with error of law. So, and I would imagine that it would often be the case that a decision made, not really often, but there will be instances when an administrative decision maker may arrive at a decision that really sounds illogical, but that alone, again, will not justify a judicial review on the ground of error of law. So in the case, for example, of Australian Broadcasting Tribunal versus Bond, Chief Justice Mason said that at common law, according to the Australian authorities, want of logic is not synonymous with error of law. So long as there is some basis for an inference, in other words, the particular inference is reasonably open, even if that inference appears to have been drawn as a result of illogical reasoning, there is no place for judicial review because no error of law has taken place. Now, we are looking at the importance of the notions of evidence or want of evidence or absence of evidence because we must remember that when a person is aggrieved by a decision of an executive decision maker, on the ground, for example, that the decision is not supported by evidence, Although the AAT would be the proper tribunal that would review a decision on the basis of a factual error or a faulty reasoning of the decision, merits review by the AAT, as we know, is not always available because, as we know, under the Administrative Appeals Tribunal Act of 1975, merits review by the AAT is available only when a specific enactment on which an administrative decision had been made provides for recourse to the AAT. So the absence of that express provision in that enactment or statute providing for recourse to the AAT, then merits review would not be available. So in that case, if merits review is not available to examine a factual correctness or a factual error, then as a solicitor, for example, you would need to determine whether or not recourse can be had to the courts, because under common law principles, courts are always open to examine excesses of the executive or errors of law. And so that's the reason why we want to examine it, because there is no need for a specific law or statute, for example, to provide for judicial review of administrative decisions, because at common law, it is already recognized that courts can examine administrative decisions on the basis of errors of law. However, as we know, under the Administrative Decisions Judicial Review Act of 1977, it is now under statute where more grounds have been clarified and put in place by Parliament that would enable the courts to undertake judicial review. But still, even then, we will realize that judicial review on the basis of a lack of evidence or an absence of evidence is in fact quite limited. So now moving on, in the case of Australian Broadcasting Tribunal versus Bond, Chief Justice Mason also said that the traditional common law principle that an absence of evidence to sustain a finding or inference of fact gives rise to an error of law. So therefore, as far as judicial review at common law is concerned, there can only be judicial review if there is an absence of evidence to sustain a finding or inference of fact, because then that absence of evidence would constitute an error of law. So it is not the absence. So in other words, under common law, it is not the fact that a decision is arrived at and there is no evidence, so therefore, judicial review is available. The reason why judicial review is available is because the absence of evidence to sustain a finding or inference of fact gives rise to an error of law. So it is the fact that there is an error of law that justifies the intervention of the courts and that allows them to undertake judicial review, not the fact that there is an absence of evidence itself. So the absence of evidence leads to a conclusion that an error of law has occurred. So that is the basis for judicial review. Now, so there are actually three instances when the lack or absence of evidence, there is no evidence, is a ground for judicial review at common law. And these are when the lack or absence of evidence constitutes an error of law. Secondly, when the lack or absence of evidence indicates that the proper exercise of the power has not arisen because the conditions for its exercise do not exist in law and in fact. And thirdly, because the lack or absence of evidence amounts to serious irrationality or illogicality, which gives rise to jurisdictional error or when there's very unreasonableness. So we will notice, therefore, that when we speak of a lack or absence of evidence to justify or to ground judicial review, we will notice that there are three aspects to this, therefore. In that case, therefore, when we speak of lack of absence of evidence, we can look at it in three senses. When that would constitute an error of law, and two, as we said, that would indicate that the proper exercise of the power has not arisen because the conditions of its exercise do not exist in law and in fact, and because three, that would amount to serious irrationality or illogicality, which gives rise to jurisdictional error or witness-bearing unreasonableness. Now, in looking at the notion that serious irrationality, for example, or illogicality gives rise to jurisdictional error or witness-bearing unreasonableness, it was said by Chief Justice Gibbs in Buck versus Pavone that a person will obtain relief from the courts if he can show that the authority has misdirected itself in law. So even if none of these things can be established, the courts will interfere if the decision reached by the authority appears so unreasonable that no reasonable authority could properly have arrived at it. So again, we will notice that such a statement by Chief Justice Gibbs is familiar because it actually is a statement that was used by the UK court in the case of the Associated Movie Pictures versus Witness-Bearing Corporation, when it spoke of the notion of witness-bearing reasonableness as a ground for judicial review. In Minister for Immigration and Citizenship versus SZMDS in the High Court, Justices Crennan and Bell also said that there would be a ground at common law for judicial review when a decision is clearly unjust or arbitrary or capricious or unreasonable in the sense that the state of satisfaction mandated by the statute imports the requirement that the opinion as to the state of satisfaction must be one that could be formed by a reasonable person. So again, this is an exposition or an elaboration of what would constitute serious irrationality or illogicality as to ground a judicial review remedy. Now, because of the enactment of the Administrative Decisions Judicial Review Act of 1977, this specific statute provided a more express ground for judicial review on the basis that a decision was not supported by evidence or other material to justify the making of the decision. And so this would be under Section 5, Paragraph 1 and Subparagraph 8 of that specific legislation. Now, we will see that the scope of the ADJR Act in relation to a review of judicial decisions on the basis of an absence of evidence or other material is actually narrower in scope because, if you will remember, for example, if you will remember, when you speak of, in common law, when you speak of the lack or absence of evidence that will then become a basis for judicial review, there were three ways by which we can say that there is, in fact, a lack or absence of evidence. One is that a lack or absence of evidence would constitute an error of law. Two, when the proper exercise of the power has not arisen because the conditions for its exercise do not, in fact, exist in law, and in fact, and thirdly, because that would then amount to serious irrationality or illogicality, which gives rise to jurisdictional error or witness-bearing unreasonableness. So, on the basis of these three examples, we can say that there is a lack or absence of evidence that would support a claim for judicial review. On the other hand, it has been observed that a recourse to judicial review under the Administrative Decisions Judicial Review Act of 1977 is narrower because if we examine Section 5 Paragraph 1, Subparagraph H of that law, it provides that a person who is aggrieved by a decision to which the ADJR Act applies may apply for an order of review in respect of the decision that there was no evidence or other material to justify making of the decision. Now, this specific provision of the law is qualified by Section 5, subparagraph 3, which provides that the grounds specified in paragraph 1H shall not be taken to be made out unless, 1, the person who made the decision was required by law to reach that decision only if a particular matter was established and there was no other evidence or material, including facts for which he or she was entitled to take notice, from which he or she could reasonably be satisfied that the matter was established, or 2, that the person made the decision based the decision on the existence of a particular fact, and that fact did not exist. So we will observe that under the ADJR Act, the idea that there is a ground for judicial review under that specific law on the basis that there was no evidence or other material to justify the making of the decision can only be made out under these two circumstances as specified by Section 5, subparagraph 3. So under the ADJR Act, therefore, it can be said that the ADJR Act is narrower because when you speak of the absence of evidence, that can only be understood in the context of, 1, the person who made the decision was required by law to reach that decision only if a particular matter was established and there was no evidence or other material from which he or she could reasonably be satisfied that the matter was established, or 2, that the person who made the decision based the decision on the existence of a particular fact, and that fact did not exist. So again, contrast that to a wider view of what amounts to an absence of evidence under common law. But as I will expound later on, in a sense, there's actually a wide scope for judicial review on the basis of an absence of evidence, as I will explain in a short while. So, under the ADJR Act, therefore, specifically Section 5, an order of review can be made on the ground that the decision involved an error of law. So, under this specific provision, Section 5, subparagraph 1, subparagraph F, when a decision involves an error of law, it can be argued that it can then be said that there is a ground for judicial review. But because the notion of error of law has actually been decided on by the courts using common law doctrines, it is possible to argue that those grounds which had been pointed out by the courts espousing common law principles as constituting grounds for judicial review on the basis of an absence of evidence, that can then be used to justify a claim that error of law should also be understood as having a decision that is not supported by evidence, and in which case a decision that is not supported by evidence should then be understood in the context of what is meant by an absence of evidence using common law principles. So, and this is a statement by the court in Australian Broadcasting Tribunal versus Bond, where the High Court clarified that it is actually possible to argue that an absence of evidence can actually justify a claim that a decision involves an error of law using case law, in which case, therefore, there is a twin application of the ADJR Act, both under Section 5.3 and Section 5.1. So that under Section 5.1F, for example, you can have a judicial review of a decision on the basis of an absence of evidence, because in that case, a claim can be made that there is an error of law as understood by common law. Now, going back to factual findings and the ADJR Act, we might be able to differently state what Section 5.3 means when it says that when that provision provides that the ground that there was no evidence or other material to justify the making of the decision shall not be taken to be made out unless there was no evidence or other material from which the decision maker could reasonably be satisfied that a particular matter required by law to be established was established. And we can say that this can simply be expressed as having there being no evidence to support an essential statutory requirement. And that other provision, which says that a particular fact on which the decision is based did not exist, that can also be simply expressed as a reliance by a decision maker on a non-existent fact. So therefore, if you look at Section 5.3 subparagraph A, for it to apply, it is essential that a decision maker must have been required by law to reach a decision only if a particular matter was established. This means that there must have been a requirement by law that a particular matter be established, and therefore that finding must be crucial or critical to the decision. And there was no evidence or other material from which a decision maker could reasonably be satisfied that the matter was established. Now, in relation to Section 5.3b, which involves a particular fact that did not exist, or there was a non-existent fact, which again is a basis for judicial review under the ADJR Act, the way this is understood is that, number one, the decision must be based on a particular fact. And so the notion of particular fact was examined in Director of Animal and Plant Quarantine versus Australian Pork Limited, where Justices Heery and Lander said that observations or comments about the evidence are not particular facts. So findings, assumptions, or predictions reflect particular facts, but they are not particular facts in themselves. As well, the particular fact must be critical to the final decision. And finally, a person applying for judicial review on this ground must establish that the particular fact critical to the decision did not exist. And the onus of proving the non-existence of a fact rests upon the applicant. Now, in Carag Queensland Mining Limited versus Daniel, the full federal court also had the occasion to examine the no evidence rule. And in that, the no evidence rule under the ADJR Act, and in that case, it had been claimed by, for example, by Carag Queensland Mining Limited, that in order for it to pay a lower customs duty under the Customs Act of 1901, it was essential that a coal mining equipment needed to be imported because it was not reasonably available for some months. So for a mining company, for example, to pay lower customs duties under the Customs Act 1901, it had to be established that mining equipment had to be imported because it was not reasonably available for some months. On the other hand, the argument was made by the Comptroller General of Customs that CORAC could actually have negotiated a later date for the supply of coal and hence delayed the need for equipment. So in that case, therefore, it was an argument made by the Comptroller General of Customs that there was no need for coal mining equipment to be imported at a specific time because it was actually reasonably available. Only if CORAC had actually delayed its importation if it negotiated a later date for the supply of coal, because if there was no supply of coal, then there was no need for the mining equipment. But Chief Justice Black, together with Justices Spender and Kama in the federal court, ruled that for CORAC, a later delivery date was actually not open to it, and hence the decision was based on a fact that did not exist. So the court then said that if a decision is in truth based in the sense I have described on a particular fact for which there is no evidence. So in this case, there was no evidence that it was open to the company to delay the importation by negotiating a later supply date for the coal, then, and that particular fact does not exist, then the decision is flawed, whatever the relative importance of the fact. So the finding of fact that Corag could have had a later date for the supply of coal was a finding of a particular fact upon which the decision was based. It was a finding that was critical to the decision in several ways. And so therefore, this was a decision on which there was actually no evidence to support it. And so therefore, judicial review was available. Now, let's move on to an examination of what the rules are when it comes to fact-finding, this time by administrative tribunals. So we have already considered, on the one hand, the appreciation by of the rules of evidence by courts. What I will then be doing in this part of the podcast is to examine the way that administrative bodies or administrative tribunals, for example, the AAT, would appreciate evidence and what the rules of evidence are in relation to them. So in the first place, a tribunal is not bound by the rules of evidence, and therefore it can receive any material submitted by the parties and in any form. So for example, evidence that is oral or documentary in form could be accepted by a tribunal. As well, the tribunal is not generally obliged to allow cross-examination to test the reliability of the evidence before it, which is obviously different when it comes to rules of evidence in the courts, because the right to cross-examine another party is a matter of right. Whereas as far as administrative tribunals are concerned, cross-examination is not mandatory. As well, a tribunal can disregard the formal rules of evidence. However, it is also generally accepted that rules of evidence distill a wealth of experience and wisdom about fact-finding, and so therefore, even if a tribunal might be said to have the right to disregard the formal rules of evidence, it is actually important for tribunals to also consider or take into account the formal rules of evidence, because they can actually be crucial in arriving at a correct or preferable decision. So therefore, evidentiary principles that can provide useful guidance can include factual claims that are corroborated, because then they should more easily be accepted because of the fact that there is corroboration. Tribunals should also consider that hearsay evidence is not necessarily reliable, and as well, a person's opinion will be more persuasive if it falls within their acknowledged expertise. So generally, therefore, as far as rules of evidence are concerned, there is the opinion rule, so that opinions by private individuals do not constitute evidence, because that is subjective. And as a matter of evidence, witnesses are meant to testify to what they know, not to what they believe, which is what an opinion is. However, if it is an expert opinion or an opinion based on an expertise of a person, then such opinion can be helpful and should be accepted, especially in the context of a merits review or in the context of an operation of an administrative tribunal. So the other rule is that the tribunal shoulders the responsibility of being reasonably satisfied on each component issue. So there is actually no burden or onus of proof on the parties to the proceeding to prove a factual claim to the satisfaction of the tribunal. The standards of proof that apply in civil litigation also do not apply in administrative decision-making, but they can actually provide some useful guidance. So in resolving disputed issues of fact, a tribunal can be guided by the civil standard of proof, which is the balance of probabilities. But this is a rule or a principle that is merely a matter that guides administrative tribunals, but is not mandatory for them to observe. So therefore, the requisite standards of proof that apply typically in civil litigation do not apply in administrative decision making. And it would also be permissible for a tribunal to accept as evidence a finding of fact made by a court in another case. Now, this finding obviously is not binding on the tribunal unless there is a doctrine of estoppel which applies, or the finding provides the statutory foundation for the new decision presently under consideration. And there is also no doctrine of administrative estoppel, so that as a consequence, a government agency is not generally bound by its own earlier decisions, findings of fact, or advice and representations, which is obviously quite different because as far as courts are concerned, there is the principle of precedent, where courts are in a sense bound by rulings made previously by courts in the past. In Australian Broadcasting Tribunal versus Bond, Justice Dean also clarified how decision makers typically should make decisions. One is that they must act rationally and reasonably. They must exclude the right to decide arbitrarily, irrationally, or unreasonably. There is a requirement that regard be paid to material considerations, and that immaterial or irrelevant considerations should be ignored. It also excludes the right to act on preconceived prejudice or suspicion. There's also a requirement that there be a minimum degree of proportionality. The other rule is that when the process of decision-making need not be and is not disclosed, there will still be a discernible breach of such a duty if a decision of fact is unsupported by probative material, and that when the process of decision-making is disclosed, there will be a discernible breach of the duty if findings of fact upon which a decision is based are unsupported by probative material, and if inferences of fact upon which such a decision is based cannot reasonably be drawn from such findings of fact. And a breach of duty to act judicially constitutes an error of law which will vitiate the decision. So after studying this topic, you should then be able to discuss and explain no evidence as a ground for judicial review at common law, no evidence as a ground for judicial review under the ADJR Act, and the rules of evidence and fact-finding by administrative tribunals.